This is continuous coverage.
Continuous coverage. Continuous coverage.
In the trial of Lori Vallow Daybell from the Hidden Killers podcast.
Hidden Killers podcast.
That it is, and we have received audio now of jury selection from day number 2 of the trial. We're trying to bring this audio to you, frankly, as quickly as we get it. It does take some time, though, for the court to process it and then release it. Hopefully, once the trial gets underway, it'll be a little more timely. But just know we're trying to deliver this to you as quickly as we get it. Let's head to the courtroom right now.
Expressed here today during voir dire, I do find it's appropriate to sustain the challenge by the state, so you will be excused for cause in this case. Thank you for your service in this case and for your honesty in the questioning. As I mentioned previously, if anybody insists on talking to you and you don't want to talk to them about your jury service, report that to the court. And if you do choose to talk to others, please respect the privacy and feelings of your fellow jurors and only discuss your own personal feelings. So that will conclude your service for today, and you can be excused.
So, to everybody else, based on that conversation, does anyone else have concerns about that? Okay. If anyone does, will you raise your hand right now? All right. So then my question to the rest of you, can you all commit that even if you see difficult information, difficult evidence, you will not allow it to overrun your common sense and reason in rendering a fair verdict? I agree to that. Thank you. I am going to turn the rest of my time over to Ms. Smith for a few more questions.
Go ahead, Ms. Smith.
Thank you, Judge. Good morning. One of the things that we're going to chat about briefly is some of the answers you might have had on questionnaires about some of the legal concepts that you kind of commented on. The court and only the court is the one who gives you the law in this case. And the questionnaire asks you about sort of general ideas on what you thought kind of coming into this process. But in the end, the jurors all have to agree that the law that they're given by the court is what they'll follow. Sometimes there's a lot of misinformation out there in the community about legal ideas and legal concepts, and we need to make sure that you don't have some sort of opinions, which we all bring with us into any room, that's going to make it hard for you to follow what the court says. And that's one of the things I'm going to chat with you about briefly in context of this process. Juror 695, and I think I understand your questionnaire. I want to make sure I read it correctly. You got part of the jury selection process, correct?
Yes, I was, what do you call this? The
veneer process, voir dire, yeah.
And then I was not chosen to be on the jury, but I was there all day.
Okay. Did you have to sit through this process and all the questioning?
Yes.
Okay. You understand that the instructions that the court gives in every situation, every trial, is based on the facts of that case?
Yes.
Okay. The court doesn't make it up. He pulls it from, required statutes under the law and from the law given by the legislature and the higher courts, but each one is uniquely tailored to each situation.
Yes.
Okay. Is there anything about that experience that's going to make it hard? Are you going to be doing a compare and contrast, or can you?
No, I went through it twice. I've been on jury. I've been called 4 times. I've been through it twice, and nothing happened. No comparison.
So you've been called 4 times, but you've been through this questioning process twice. Okay. Now, let me talk to you a little bit. And the court read you the instruction on sort of the burden of proof and the process in this case. And you heard about beyond a reasonable doubt, correct?
Yes.
Okay. So let me break it down just a little bit and ask you some questions about, in context of some of your prior exposure. You understand when the court is talking about the burden of proof, that relies on the prosecution only.
Yes.
Okay. And the court will give you those instructions, definitions of what each of those crimes mean.
Yes.
All
Which
right.
I would need.
Yeah. Well, and that's why the court gives it to us, so that we're all, like Mr. Wood said, all operating on the same definitions, right?
Right.
And those definitions will have parts. And we call them elements, but they're really just parts. They're like ingredients in a recipe, right?
Okay.
And we have to prove each one of those parts beyond a reasonable doubt.
Right.
All right. And what happens if the state proves 3, but there are 4 parts, and there's a 4th part that we fail to prove beyond a reasonable doubt? What happens?
Well, I'm not clear on that. If it's
Okay.
because you have the conspiracy and then you have the actual murder, and so is there a conspiracy and not that? Would you be convicted on that and not on that?
Well, and this is why we.
At that point, I'm going to interject a little bit. We're going to get into legal definitions and legal instruction, which is the province of the court. So I understand the answer. Nothing wrong with it. But if we'd move on to more appropriate voir dire questions, please.
Yes, yes. And I'm not going to define anything. That is absolutely the court's job. Each crime, without getting into it, the court will provide those definitions for each separate crime. So the jury evaluates each thing separately. Does that make sense?
Yes.
Okay. And the state has to prove each one of those individually beyond a reasonable doubt.
Yes.
All right. If there is a part of one of those for that particular charge that you found the state did not prove beyond a reasonable doubt, could you, even if you believe the other charges, could you find someone not guilty when the state didn't prove part of a charge?
Yes.
Okay. You understand that would be the job of the juror to do that?
Right.
All right. Do you have confusion on that issue?
No.
All right. You understand in context of that if the state fails to prove its case, Ms. Vallow Daybell never has to do anything, right?
Right.
The job, and it's only the job in this case, to prove Ms. Vallow Daybell guilty.
Right.
Okay. And that she is presumed innocent unless and until the state proves beyond a reasonable doubt she's guilty of one or all or none of the charges.
Yes.
All right. Thank you. Let's turn towards juror 1020. Good morning.
Morning.
Did I read your questionnaire correctly that you were part of the Marines?
Yes.
All right. Well, thank you for your service. It looks like it was for quite a period of time.
Only as much time as they made me be there.
Well, you were there, and we thank you. But my question is, what did you do in the military?
First and foremost, we're a rifleman. And second after that, I repaired machinery, towed artillery, tanks, minesweepers, things like that.
Okay. Did you ever serve overseas?
Yes.
Where?
Iraq.
Okay. Did you ever have to see any combat?
Yes.
Okay. So that's going to lead me to some questions specifically on that issue. Is there anything about that experience that will make it difficult for you to evaluate evidence that may include pictures of a sensitive nature?
No.
Okay. Can you put any sort of exposure you might have had to those issues sort of aside and focus on the evidence you hear before the court?
That's correct. I'll do my duty.
Okay. Thank you, sir. Juror 1219. Thank you. And forgive me, sir, I failed to write down. What do you do for a living?
I manage a company that we do suspension work on vehicles. So we also manufacture lift kits, sell them worldwide.
All right. Thank you. Now, juror 906. I see that you are an EMT. Okay. Is that here in Ada County?
Yes.
Okay. Do you ever have any interaction with the coroner's staff?
Only
In the
on a
worst.
transfer basis
Okay.
on scene.
Okay. Did you recognize any of the names? And I didn't see that marked, and that's why I'm just double checking.
No.
Any of the names on the proposed witness list?
No.
Now you're going to hear from some, but not all, but you might hear about all of those people. Is there any of those names that even seem familiar?
No.
All right. Let me circle back on some of the potential scientific issues in this case. You've had some medical training?
Yes.
Okay. Have you heard the phrase cause of death?
Yes.
Okay. Have you ever had to be part of a coroner's inquiry?
No.
Have you ever had to testify in a case that involved a questionable death, either on a civil side or the criminal side?
No.
All right. In evaluating evidence, the court is going to give you definitions and tell you what the state has to prove, right?
Yes.
Okay. But the court is not going to tell you how the state has to prove its case. Does that make sense?
Yes.
Okay. And so he's not going to give you a list of evidence we must supply in order to consider convicting someone.
Yes.
All right. And the instructions from the court are going to be very specific that the state has to prove, the jury has to use their reason and common sense to believe that the state has proved each part of the charges. But he's not going to give you the formula that we have to follow to get there.
Yes.
Okay. Now, in cases involving homicide, death at the hands of someone else, the state has to prove that a particular person was part of and contributed to the death of a person. So it's death at the hands of others. Does that make sense?
Yes.
If the state supplied evidence that a person was killed, murdered at the hands of another, and the evidence, you believe that evidence beyond a reasonable doubt that someone was responsible for causing the death of a person, but the state couldn't give you the precise reason or way the person died, what mechanism caused their heart to stop beating or their brain to stop functioning, but you believed beyond a reasonable doubt that the person was murdered at the hands of one of the people involved, or, as a result of the conduct of one of the people involved, could you consider convicting someone of murder?
Considering what was brought forth evidence-wise, yes.
If you believe the state proved its case beyond a reasonable doubt, even though they couldn't tell you how a person died?
Yes.
Okay. Juror 695, I saw you kind of sit up, and it may be just stretching, but I want to make sure that I don't miss somebody. Thank you, sir.
Well, I'm just confused. If you don't know exactly how they died, then I would just have to listen to everything and figure it out.
Right. And that's the job of any juror. You would have to listen to all the evidence, take the instructions of the court, and decide whether the state proved beyond a reasonable doubt all of the parts of the crime to see if you believed the person was responsible for contributing or causing the death of a person.
Yes.
Okay. Even if the state couldn't tell you that even when the state could not tell you exactly how the person died, whether they were shot or stabbed or strangled, but they certainly were dead at the hands of someone else.
Okay.
Does that make sense?
Yes.
Okay. Any confusion?
No, I don't think so.
Understand. And that's where Mr. Wood's analogy on that pilot comes in. That's why he does that is, look, there are some times on cases that jurors are like, look, maybe this isn't the case for me. But in this situation, it is way too important to Ms. Vallow Daybell and to the people of the state of Idaho to have I think or I hope. It's about, and that's okay. The question is, do you think you could consider convicting somebody in a situation where the state could prove that a person was dead at the hands of another? They just can't show you exactly what caused the heart to stop functioning.
Right.
Could you do that?
Yes.
Okay. Now, I saw all of you listening attentively to that line of question, and I'm not going to, for expediency's sake, I'm not going to ask each time, does anybody have a reaction? But since I hadn't made that clarification first, everybody heard those conversations I heard was 695, correct? I see nods from the whole panel. Does anybody have a reaction or a concern to that line of questioning? Okay, I see everyone saying no, that they can follow the law and apply the law given, correct? Okay. I believe I'm done. Your Honor, let me just double check with my colleagues if I may.
Sure.
One more, Your Honor.
That's fine.
Let me pull it up. Juror 1219. There's a little bit of confusion, and it's probably my poor note taking. Did you mark that you might have a hardship?
Not really. Work was kind of a question, but I've talked to my employers, and it'd be more of a hardship for them than me. But, they said that if it comes down to it, they can make it work, whatever they have to do, so.
Okay. Thank you, and thank you for checking up on that. We just wanted to make sure we didn't miss something. All right, and there's nothing about that work situation that's going to make it so that you can't give both Ms. Vallow Daybell and the people of Idaho a fair trial?
No.
Okay. Thank you, sir.
All right, at this time then we'll allow for voir dire question from the defense. Mr. Thomas.
Morning. I'll be brief because most of the questions have either been asked by the judge or the prosecuting attorney, so I'll try to be brief here. So I know that the prosecutor said something to the effect of given everything that you know about this case, can you set all that aside? And that's kind of hard to do because you really don't know what you don't know, right? So have any of you seen a car accident? Have you ever witnessed a car accident? Anybody? Yeah. We've all seen fender bender or something. So if somebody were to say, okay, well, set everything you saw aside, and I'm going to tell you that there was no car accident. It was just something that you just saw. That'd be really hard to do, right? So we need you, and going back to something that the prosecutor said, we need to be brutally honest. If you know something, you need to say something. See something, say something. If you know something, we really need to know because we really don't want to get into a situation where we're in the middle of trial and a witness gets up on the stand and you say, oh, geez, man, I should have said something that I actually watched an interview of that person, or, gee, I know a little bit more about this and somebody's made an objection and now something's not coming in, but I know something extra, right? Does that make sense to everybody? It kind of does. So we're going to get a little bit into the media, and I don't want to get into it right now, but that's something that we're going to get into, and that's kind of one of the things I want you to keep in your mind. Like, maybe I'm not the right fit for this jury if I know something about something that, that may not, that everybody doesn't know. So that's that. Now, 1020, you're a musician? What do you play instrument, or are you a singer, or what do you do?
Country music.
Country music, right on. All right. And have you been doing that a while?
Yeah, since last 4 years.
Okay. You in a band?
No, I'm a solo musician.
Oh, okay.
Yeah.
All right. So you were also in the Marine Corps?
Yes.
Did you ever serve in Pensacola, Florida?
No.
No. Okay.
No. My father did.
Did he really?
Yeah.
All right. I knew a good friend of mine is a colonel in Pensacola. So, you indicate that you don't watch the news too much?
No.
Okay. Do you know anything about this case?
No.
Okay. All right. Thank you. 906, you indicate that you're an EMT. You've seen some pretty bad stuff. Car accidents are kind of like bread and butter for you type thing, right?
I work at more of a local setting at a company, so.
Okay, so maybe not so many car accidents.
County, but yeah, not so many car accidents.
Okay, all right.
Can't
They
talk
happen.
Sorry, we can't talk at the same time. It will be very difficult for the courtroom.
Right, I apologize. Is there anything you need me to repeat, or? Okay. And so you work at a company?
Correct.
And so, what kind of stuff do you see as an EMT?
Mostly work-related injuries.
Carpal tunnel?
Unfortunately, some of that, but I mean, actual injuries.
Oh, okay.
Acute and sometimes chronic, like you.
Gotcha. Okay. All right. You said something. You know what? I'm gonna wait, and I'm gonna have another question for you, but I'm gonna wait until there's a specific time that we're gonna talk about the media exposure. So I'm gonna wait on that. Okay. So I'm done with him. Thank you. Let's see. 1219. You indicated that you had some exposure on online news outlets. Do you watch podcasts at all?
No.
No? Okay. Do you watch YouTube at all?
If it's a directional video that I need, or instructional video, something like that, then I'll watch YouTube.
So mostly work-related type stuff?
Yeah, for the most part.
Okay. All right. And you make lift kits, is that right?
Correct.
For for trucks?
Trucks, yep.
Okay. All right, cool. That's all that I have for him. Thank you. 1167, you're the dentist, and we talked a little bit, and I feel like maybe I was a little bit sharp, and I was kind of picking on you a little bit, but I wasn't. I'm actually trying to help you out if you needed to get out. I have a brother-in-law who's a dentist, and I know that it's hard work. I mean, there's a lot of hands-on work type going on. So, is there anything that I said about being able to set things aside and being able to set what you know about this case aside and be able to focus in on the case? Is that a problem for you?
No, I don't think it is.
Okay. All right. Okay. Thank you. And 1159, I haven't heard from you at all, actually. So tell me a little bit about yourself. What is it that you do?
I'm a software engineering manager.
Okay. And looks like you went to the U of I. Did you live here most of your life? Are you a Boise resident?
I've lived in Boise for 30 years. But
Okay.
grew up in California.
Oh, okay. Where in California?
North Coast, Crescent City, far North Coast.
Okay. How far is that from San Fran? I'm familiar with San Francisco.
Over 300 miles, although I also lived in the Bay Area for 4 years.
Okay. Okay. So it says here that you've been called several times to jury duty, but never been put on a jury.
That's, one time I was selected for a jury, but before the trial started, the defendant changed their plea, so it never went to trial.
Oh, okay. Okay. And how did you feel about not having to, like getting in the hot seat and then being relieved of it, was that a real relief, or was it kind of like you kind of wanted to sit on it to figure out what was going on?
Well, it would have been interesting, but it was something of a relief. It was going to be a difficult trial.
Okay. And I have a couple of questions for you as well, but they're mostly for the media section. So, all right, Your Honor, I think that's all I have. I would ask the court to do individual voir dire at this point.
Very well. Thank you, Mr. Thomas. All right, counsel, the court, upon reviewing the questionnaires, I think everybody needs to be talked to with the exception of Juror 1020. I just didn't see anything in the questionnaire that I thought merited individual voir dire. If you'd take a moment and review that questionnaire and let me know if there were any issues you thought needed to be discussed, we can include that. If not, we'll talk to the other jurors.
The defense doesn't have any issue with 1020.
Neither does the state.
Okay, so the parties will pass 1020 for cause. Is that correct from the state?
Yes.
From the defense?
Yes, Your Honor.
All right, so juror 1020, you'll just be waiting while we talk to the other jurors, and then we will have juror 695 remain seated, and everyone else can be taken to the jury room while we do individual voir dire. Why don't we all rise for the jury and stretch our legs a little bit. All right, thank you. Please be seated. All right, Juror 695, you've had some responses in your questionnaire that indicate some knowledge of this case, and we need to question you about that. As I've said to many people in this case, there's nothing wrong with following the news and reading about things that interest you or keeping up on current events. The question we have here is whether or not it would be appropriate for you to serve as a juror given what you know about this case already. So to start off, I have a couple of questions of my own, and then I'll let the attorneys conduct their questioning. Before you reported for your questionnaire last week in this case and up till now, were you aware of what this defendant was charged with, including here or anywhere else, before the court told you what the charges were?
Yes.
And what specifically did you know?
I knew that she was charged with possibly murdering her children.
Okay. And did you know any more detail about the charges themselves?
No.
Okay. In the past, have you reviewed or seen any television programs that focused on this case, like a Dateline special or a 48 Hours or a made-for-TV movie or a Netflix documentary or anything like that?
I don't watch television.
Okay. Run across or view anything devoted to this case on the internet, like on a YouTube channel or anything like that?
No, the only source I would have would be the newspaper, the Idaho Statesman.
Okay, you read the Statesman. Okay. That concludes the questions the court would have for this witness, or I'm sorry, this juror 695. Mr. Wood, if you'd like to conduct individual voir dire, you can.
Juror 695. let me grab my computer real quick. You've stated you don't watch the news.
No, we don't have cable. We don't have TV in our house.
Okay. Do you have any internet streaming channels like Netflix?
We have Netflix, and I do watch. So on the internet I would watch or listen to Boise State Radio, and NPR, and then, like I say, the Idaho Statesman, which is both hard copy, and then the online version.
Okay. So it's fair to say you consume a fair amount of news.
Yes.
Okay. And I'm sorry, I wasn't quite sure. Did you say you do have Netflix or you don't have Netflix?
We do have Netflix. We do have some streaming.
Okay. Do you recall if you watched a Netflix special dealing with Miss Vallow Daybell?
No.
Okay, you didn't. Going through your questionnaire, and just to start, there's nothing wrong with watching the news.
Right.
There's nothing wrong with knowing things, right? We're here today to determine if this is the best case for specific jurors. In your questionnaire, it would indicate you know a fair amount about this case. Would you agree with me that you know a fair amount?
I know what it's about, yes.
Okay. And on your questionnaire, it asks if any of your possible exposure to reporting dramatized depictions or other publicity has caused you to form an opinion about the defendant. Do you recall how you answered that?
No, I don't. I don't think I have an opinion about the defendant. And I can tell you where my one concern is, that I first became aware of, so the kids are missing, and I first became aware of the possible reason they were when Lori Vallow and Chad Daybell were in Hawaii. And so my main, question there is, if your child is missing, are you going to go to Hawaii?
Sure.
Unless you know something.
Okay. And let's talk about that, because in your response, if it's okay if I tell you what you wrote, you did mark the box, yes, you'd formed an opinion, and said, I think she knew or knows what happened and concealed that knowledge. I think she was involved to some extent in Tylee and JJ's deaths. And again, there is nothing wrong with watching the news, forming opinions. We all do that. Can you see how, to the state, who's trying to make sure there's a fair and impartial jury and trial, and to the defendant who wants a fair and impartial trial, how that statement could be concerning?
Yes, I do. And I can say on the flip side, I have absolutely no idea what happened. I stopped paying attention because everything was so sensationalized, and I can't stand that stuff. So I can honestly say I have no clue if she was part of it or not.
Okay.
But I do think she knew what happened because she went to Hawaii.
Okay. All right. And again, nothing wrong with reading the news, nothing wrong with having opinions. But, Your Honor, based on that, the state would move for juror 695 to be excused for at least implied bias.
All right. Any response from the defense on the challenge?
The defense agrees, Your Honor.
Okay. The court's reviewed the questionnaire as well and agrees that there's been shown a bias has been formed that may not be able to be set aside in this case based on pretrial publicity and exposure to the story. So juror number 695, we very much appreciate your candor in answering your questionnaire and the questions today. Thank you for your time and your jury service, and you can be excused. You're welcome. Let's have juror 906 brought in next. That's fine, Mr. Archibald. All right, juror 906 has returned for individual voir dire. The court's reviewed your questionnaire, and it appears you've had some exposure to media coverage in this case prior to being called for jury duty. The questions we want to get into at this time are whether or not your prior knowledge of the case may serve to potentially disqualify you from serving on this case. So I'll start off with a few questions of my own for juror 906. Let me ask you first, before you reported for your jury service in this case last week to get the questionnaire, did you know what the defendant had been charged with here or anywhere else?
Not formally, no. The formal charges, no.
Okay. Have you watched any news programs that focused on the case, such as Dateline or 2020, or any documentaries or made-for-TV movies or anything like that?
No, just normal KTVB news coverage that a couple years ago, 2020, when it was an original topic, right? When it was fresh.
Okay. Those are the questions the court had on individual voir dire. If the state would like to inquire, you may.
Good morning.
Morning.
We noticed on your questionnaire you made some comments about that the news is not always accurate, right?
Yeah.
Okay. And this really is about fairness. Both sides in this case deserve to try and be judged on the evidence and the burdens on the state that's only presented in this courtroom, right?
Yes.
Okay. And so one of the reasons it's so important that we question you on these things is we need to make sure that anything you might have seen on a news channel isn't going to be in the back of your head while you're listening to the evidence on this case or while you're assessing whether the state proved its case beyond a reasonable doubt. Do you understand that?
Yes.
Okay. Is there anything about the news segments you saw that you think, hey, it's made me, form an opinion on her guilt or on her guilt?
I wouldn't say so, no.
Okay. You understand that the jurors in this case have to commit to anything they might have heard, assume one, it's not true, and two, put it out of their head. Can you do that?
Yes.
All right. Now, looking at your specific answers, let me pull it up real quick. Of course, my computer went to sleep right that second. You said specifically, no, I think it's only fair to judge based on evidence as news is not evidence.
Correct.
Do you still believe that statement?
Yes.
Okay. Anything that's occurred in here that's changed your mind about that?
No.
All right. And then you also made a statement that you would say her involvement is suspicious. Have you heard any actual evidence?
No.
Okay. If the state fails to prove each part of the crimes, if we fail to prove any part of the crime or crimes given to you, what must your verdict be?
Not guilty.
Okay. And is there anything about what you've seen or heard that's going to cause you to hesitate to do your job and find her not guilty if we don't prove it?
No.
Okay, thank you. Nothing further.
All right, thank you, Ms. Smith. The defense may conduct individual voir dire of this juror.
Morning, Juror 906. How are you doing?
Good, how are you?
Good. So you indicated that you've watched some KTVB, some things there, and you indicate that you know that the kids were found in Rexburg. Is that right?
Yes.
And what else did you hear on the news? What else do you know about the case?
Chad Daybell is involved, not directly with this trial, but his wife. I don't really have any concrete answers to that question. I don't know a lot, so.
Okay. When you indicated that there's a question on the questionnaire that says, have you formed any personal opinions whatsoever based on information from any source of Lori Noreen Vallow, a.k.a. Lori Noreen Daybell's guilt or innocence of anything? And at first it looks like you hit no, and then you scratched it out, and then you hit yes, and then it says, if yes, briefly explain, and it says, I would say that her involvement is suspicious. And so what's suspicious about it?
I think for that answer, right, and I'm only vaguely remembering the KTVB random bits I saw early 2020s, but the lack of having an answer of like where your kids are, right, that's just like suspicious, right? I think that's why we're here, both sides, right, to argue whether or not there's any guilt involved, but I mean, it's suspicious, right?
So what did you hear about? She didn't know where her kids were. What did you hear about that?
Just the news coverage, media asking, right? I think they were in some part of Hawaii, and not being able to answer, like, where the kids were, right? And that's really where I was getting at is, like, that's just a suspicious thing.
Okay.
Guardianship, right? Guardianship-wise, right?
Okay.
But, I don't know. That's just weird.
Okay. And so you didn't follow up on any of that? You didn't hear anything else on any of the... You don't follow on social media or anything?
No.
Do you have social media?
I do.
You have Facebook?
I do. And you see, like, an article pop up, but I don't click into them, especially since we've been told not to, right? So.
Right. But a lot of that stuff happened before you came to court, right?
Correct.
Okay.
But I didn't necessarily open them.
Right, right. Were you curious at all before you were called to jury duty?
I can't say I thought much of it other than another story, right? So I don't really get into the news much.
Okay. When you were called to jury duty, did you talk to anybody about having jury duty?
Just like my employer and my family that I'm maybe on this case, right? Well, on the case that'll last, right?
Okay. And so you talked to your family about being on a case that might last 8 weeks, and did somebody say, yeah, that's probably the Lori Vallow case?
I think there's a lot of assumptions, right? I mean,
and that's what we're trying to get at. What were the assumptions that were made? What do you know about what was said? What was said to you?
Can you elaborate? I don't know. What's your question?
Well, when you were told that you were having jury duty and you told your employer, did they say anything about, oh, that's probably the Lori Vallow case, or this is what happened in that case, or did they?
Of course, yeah. I mean,
so what were the kind of some of the things that they said?
Well, just like, oh, is that the Lori Vallow case? And of course, I can't confirm or deny, right? But I mean, I think it's probably and I don't know this, but maybe the only case that has such a large sampling of jurors, right?
Right.
So I think the assumption is fairly made by most people.
Yeah.
Right.
And was there any discussion about what the Lori Vallow case was about?
No.
No? Not with your family?
No.
Okay. Your Honor, based on his response on page 16, paragraph F, lines 19 through 23, where he indicates that he had formed an opinion and that he would say that her involvement was suspicious, I'd move for cause to dismiss this juror.
Let me ask a follow-up question or two of juror number 906. When you recall footage you saw about Hawaii, do you recall seeing any footage of the defendant herself or her saying or stating anything in the footage you viewed?
I don't recall if anything was said, but footage of the media seeing him walking and attempting to ask questions, right, is what I'm recalling.
All right. Does the state have a response to the challenge?
Yes, I think given this juror's answers to simply base answers here in court and his answers on the questionnaire where he specifically says, I think it's only fair to judge based on evidence. The news is not evidence. Coupled with his attitude and demeanor here before the court, there's nothing to merit any strike for cause. The box that is checked that defense counsel noted didn't provide context, didn't provide an instruction or anything that would suggest that would give him what his duties were as a juror, and it did not give him an opportunity to say whether or not he could follow his duties as a juror in the courtroom. He was given that information by the court, and on questioning from basically all three parties, he indicated he could do his duty.
All right, I've considered the challenge in this case and looking at the standard also set out in Idaho Code 19-2019, subsection 2, and that's the sound discretion of the trier of fact as to whether there's an inference based on these questions that this juror would or would not act with entire impartiality. It is concerning that there was exposure to publicity in the case. I've heard that explanation on question 10F, and that was concerning as well, but having considered the follow-up questioning as it relates to this juror's commitment to following the instructions of the case, I don't find that this would rise to the level requiring a challenge for cause to be sustained, so I'll overrule the challenge as to juror 906, and I believe unless there's any further voir dire in light of that, we'll conclude our individual voir dire. Does the defense have any further voir dire? Okay, so juror 906, she'll return to the jury room and we'll bring out our next juror for questioning. That will be juror 1159. All right, juror 1159 has returned for individual voir dire. The court's reviewed the questionnaire responses, and this juror presents some knowledge of the case from prior news coverage or other sources, and so those are the topics we want to discuss with you at this time individually. I'll ask you a couple questions of my own, and then the attorneys will be allowed for further questioning. So, before you reported for your jury service last week when you got your questionnaire, did you know what the defendant had been charged with here or anywhere else?
Not in any detail, but yeah, I knew there was a charge, likely murder charge.
Okay, and can you just explain as specifically as you can what you knew about charges that had been filed?
I wouldn't say I knew anything about the charges being filed other than I knew it was a murder case and charges had been filed. So that's really the extent of my knowledge.
Okay. Have you ever viewed any news programs or documentaries or movies that focused on this case, like a 2020 or a Dateline or a Netflix documentary or anything like that?
No.
All right, that concludes the court's questions for Juror 1159. If the state has an inquiry, you can do that at this time, Ms. Smith.
Had to check the clock. Good morning. I just want to ask you some follow-up questions on your questionnaire. Do you have Netflix?
Yes.
Okay. Did you see anything on Netflix about Ms. Vallow Daybell or anything about this case?
No.
Okay. Prior to me saying that, had you known there was anything on Netflix?
No, I was not aware of any Netflix related elements.
Okay. I did notice on your questionnaire there's a couple of things that you mentioned knowing about. Have you heard, you said very little, I recall seeing pictures, I think, a young boy and a young girl who I thought were JJ and Tylee, and when they were described as missing and assumed deceased. Where did you get that information or that fact you stated?
I think probably local TV news.
Okay. And did you ever hear about when the kids' remains were found?
Not that I recall.
Okay. Online news sources. Do you put that in your questionnaire that you said I saw, maybe have seen some things on online news sources? Any national news or only local online news?
I don't recall seeing it on national news, although I suspect I probably have in passing, but nothing that I watched, intently.
Nothing on like Dateline or 2020 or any of those type shows? No,
would have been, national NBC, CBS News type.
Okay. Now, I just need to ask, you heard the line of questions about the state's burden of proof, right?
Correct.
And it really is about a person who can be fair to both Ms. Vallow Daybell and the state of Idaho. You agree with me?
Yes.
Is there anything about what you think you remember or what you saw that's going to make it hard for you to be fair and impartial going into the case for Mrs. Vallow Daybell?
No.
What about the people of the state of Idaho?
No.
Okay. You understand that the parties in this case have the right to be judged and have the case evaluated based on only what is allowed by the court here?
Yes.
Is there anything about what you saw that you're going to be thinking about as you're sitting there watching the witnesses testify or seeing evidence come in?
No.
Can you assure us that you can put that out of your mind?
Yes, I can.
Okay. Now, may I ask a quick, and I apologize, Your Honor, I missed this before, just a quick hardship question? I can do it later, or I can just, it's not.
Yeah,
long.
let's ask the hardship issue now.
Okay. There's just a little bit of stuff written on your questionnaire where you said you could fulfill at least some of my obligations in the late evening or afternoon, but you later said it might be employment status is protected. Do you remember that?
Yes.
Okay. Have you had a chance to check with your employer about if you were to get called for service for an extended period of time?
I have.
Okay. And what was their answer?
Basically, we would figure out how to make it work.
Okay. Is there anything about that that's going to be sitting in the back of your mind affecting your ability to concentrate and assess witness credibility or judge the evidence?
I don't believe so.
Okay. The reason we ask that, we want to make sure there are no distractions, that you can focus and, be 100% present.
Yes, I understand.
Okay. Any concerns?
No.
Thank you, sir.
All right, thank you, Ms. Smith. Mr.
Thank you, Judge.
Thomas, if you'd like to conduct individual voir dire of this jury, you may.
Juror 1159, you indicate that you recall seeing pictures of a young boy and a young girl who you thought were JJ and Tylee. Do you recall what you saw? What were these pictures? What do they look like?
They were like school pictures, maybe. I mean, just individual headshots.
Kind of like a mugshot or a headshot?
Yep.
Okay, headshot's probably better. Okay. And that was just on a like a news feed, or was it a nightly news type thing, or what do you remember?
Either nightly news or online news.
Okay. Do you ever get on YouTube
Yes.
and kind of go down some rabbit holes on that? Did anything on the Vallow case ever come up?
No, I haven't seen anything on this case on YouTube.
No? Okay. And I think the prosecution asked you about Netflix and whether or not you saw the Netflix special. There was also, it was trending for a while. Do you watch Netflix on the daily or just every now and then, or how does it work?
Infrequently.
Infrequently? Okay. So it's possible that you didn't see the trailer or anything about this case?
I don't recall seeing it.
Okay. All right. You didn't see anything on Facebook or LinkedIn, anything like that?
Not that I recall, no.
Okay. You a TikTok guy?
No.
Yeah, me neither. All right. Thank you.
All right, thank you, Mr. Thomas. As for Juror 1159, then, does the state pass this juror for cause?
Yes, Your Honor.
Does the defense pass them for cause? Okay, thank you. Juror 1159, if you'll just return to the jury room with the bailiff, we will have Juror 1167 come in next. Okay, juror number 1167's been returned for individual voir dire. You've indicated some knowledge of this case through viewing news reports or pretrial media exposure, so we want to discuss that specific topic with you at this time outside the presence of your fellow jurors. Just a few questions the court will have for you, and then I'll let counsel inquire. First, before you reported for your jury service last week to fill out the questionnaire, were you aware of what charges, if any charges, had been filed against the defendant here or anywhere else?
No.
Okay. Have you ever watched any news programs that focused on this case, in particular, like a documentary, a 2020 special, a Dateline special, or made-for-TV movie or anything like that?
No, really the only exposure I had, I think I wrote on my questionnaire, probably 3-4 nights a week, my wife and I, just while we're getting ready for bed, the local news is on. And most of the time with that, even I have 2 children that we're trying to get down to bed as well. So it's kind of real hit and miss. But that is probably my exposure to this.
All right, that concludes the court's questioning. At this time, if the state would like to inquire as to Juror 1167, you may.
Juror 1167, thank you. So you, just so to make sure I understand, you said you at night have the news on as you're going to bed and getting your kids ready for bed?
Correct, yes.
Okay. I believe you stated in your questionnaire, I don't want to misquote you, you were familiar with the defendant's name.
Yes.
Do you have Netflix?
Yes, we do.
Do you recall if you've ever watched anything about this defendant on Netflix?
I know you're referring to the documentary that is on Netflix, and I have not watched that.
Okay. Do you know if you saw a trailer for it or?
Not that I can recall.
Okay. Do you recall any specific stories you might have seen on the nightly news as you were watching it or getting your kids down for bed about the defendant?
I would say the part, the only part of it that kind of comes to mind with any clarity was when the defendant was in Hawaii.
Okay. All right. And did anything about that, on your questionnaire, you state that none of the news reporting has led you to form an opinion about the defendant's guilt?
No. I haven't formed an opinion. Also on the questionnaire, my wife is an attorney, and so she was a clerk for a federal judge, and so I've kind of been exposed to the court system, and so a lot of times, like my philosophy with regards to the judicial system, she's always preached to me, hey, it takes fair and impartial people to make the system work. And so, I don't think any of these things, I understand what needs to take place to form an impartial jury.
Okay.
And to try the case.
And so you've answered this on your questionnaire, but just to clarify for the court, is it still your position that any of the news you've seen, that none of it has caused you to form an opinion about the defendant's guilt?
No, it has not.
And you understand that she comes in to court today with a presumption of innocence?
I definitely do.
And it is only the state's job to prove the case against her?
Yes.
She doesn't have to do anything?
Correct.
Okay. And nothing you've seen in the media would cause you to change your mind about that, correct?
Correct.
Okay. The state has no further questions.
All right. Thank you, Mr. Wood. Mr. Thomas?
So the only question I have is about the Netflix series. You indicated when Mr. Wood asked you if you had Netflix, and then you kind of jumped in and said, well, I think you're talking about the Netflix documentary. Mm-hmm. So how did you hear about the Netflix documentary?
Through friends and, that had seen the documentary.
Oh, and they've talked to you about it?
Yes, they have. Back then, it was one of those.
Right.
It was one of those conversations. Hey,
it was trending number one. I'm sorry, Judge. I didn't mean to talk over him.
No, I was just saying. Yeah, it was a typical conversation. I'm always having conversations. What good series is anybody watching on streaming? And it brought up in conversation.
Yeah. And what was the conversation about? What was said about the Netflix series?
Oh man, you're asking me to recall specifics. It's hard to recall specifics. Probably something in the light of this was interesting.
Nothing good, right, about my client?
I don't remember anybody bashing your client or anything in specifics of that nature.
Okay. All right. Do you recall the title of the series?
I do not.
Okay. Your Honor, in light of what he may recall later on when we have actual witnesses testifying about his conversations with friends and family about this Netflix series, I would move for cause on implied bias.
All right, what's the state's response?
Thank you, Your Honor. I think the potential juror, has made it very abundantly clear that he has not formed any opinions. He understands this process. He understands the presumption of innocence and the burden on the state, and that he has no prior knowledge that would prejudice him against the defendant. And so we would object to that motion.
All right, the court's reviewed the challenge for bias on this juror after questioning and reviewing the questionnaire. The court finds it would be speculative to indicate that there was any bias shown based on the candid responses of the juror, so the challenge is overruled, and I understand the state passes juror 1167 for cause. Is that correct?
Yes.
All right, and the court will overrule the challenge, so juror 1167 will return with follow-up instructions in a moment. You'll return to the jury room, and we've got one more potential juror to discuss individual voir dire with, and then I'll give you further instructions. Thank you. You're fine. All right, juror 1219 has returned for individual voir dire. We wanted to ask you some additional questions to follow up on your questionnaire responses. You've indicated some knowledge of this case through watching news about the case before you reported as a juror. I'll have a few questions to just start off with you. Before you came in for the questionnaire last week, did you know what this defendant was charged with either here or anywhere else?
I guess I would say I knew that they had been charged with something as far as the kids, murder or whatever.
Okay. Did you know any more particular details about that?
No.
Okay. Have you ever watched anything like a Dateline or a 2020 special or a special news program that focused on this case, or a documentary or movie or anything like that?
No.
Okay. That would conclude the questions I have for this juror. If the state would like to conduct their individual voir dire, you may.
Good morning. I'm rushing us. Thank you. I do have a couple quick questions about some of the answers you had on your questionnaire. What was the source of your knowledge or what you believe the charges were? Where did you get that idea?
I'd seen a few headlines here and there, never really read the stories, and then just hearsay people talking about it.
Okay. Seen some headlines. Like, where did you see the headlines?
Probably it would have been on like local news, I guess.
Okay. When you say local, like your local TV, your local paper?
It would have been probably local online, yeah.
Okay. Do you have Facebook?
No.
Okay. Do you use, probably not, but I gotta ask, do you have Instagram or Twitter or and on YouTube, do you have a user account with YouTube?
No.
Okay. So if you've seen the headlines and you knew about some of the charges, did you ever read any of those stories?
Not really. I honestly try to avoid the news. I just found that it, causes me unnecessary anxiety, whatever you want to call it, throughout the day. So that's part of the reason I got rid of all my social media a couple of years ago.
Gotcha. A lot of people have done that. My question is, you said you kind of heard the hearsay or the, people talking. What people do you remember hearing talking?
I guess a couple guys at work, they had just said something along the lines of, they, had found the kids, and then, they had made some arrests from it. So there was not really anything in detail about it. But
how long ago did you have were these people talking about this?
It would have been, I don't know, 6 months ago, a while ago.
Okay. Did any of those people express opinions?
Not that I can remember.
Okay.
I think it was just more of a, blanket statement about it. So.
All right. What about once you got your jury summons? Did the people at work kind of talk about it again?
No.
Okay. What about once you had to talk to the people at your employment about being here? Did it come up?
No, I told them there was a chance that, I could be on jury duty for a couple months, and they never mentioned anything specifically about what case it was or anything like that. But
okay. Is there anything about that experience or that sort of headlines, the conversations that you're going to hold against Ms. Vallow Daybell?
No.
You know that both sides have to come into a case with sort of a clean slate, right?
Yes.
Okay. And one of the reasons we ask these questions is to help make sure that jurors in your spot aren't sitting there thinking about something they saw outside that neither party can do anything about.
Yeah.
All right. Any concerns about your ability to kind of put any of the comments from colleagues or anything you might have seen on the local stations out of your head?
No, I have no concerns with that.
Okay. Thank you. The state will pass.
All right. Thanks, Ms. Smith. Mr. Thomas Murdaugh?
Briefly, Judge. I'm a little bit concerned about things that you had heard from other people talking about things that they had seen or heard. And so I just kind of want to delve a little bit into that. Did you hear anything about a gentleman by the name of Alex Cox?
No.
No? You don't know who he is?
No idea.
Okay. Did you hear anything about Ms. Vallow's, any other issues that Ms. Vallow may have in other states?
Nope.
No? Okay. I have no further questions.
Okay, thank you. So, as I understand, then the state would pass for cause juror 1219, is that correct?
Yes, Your Honor.
Does the defense pass this juror for cause?
Yes, Your Honor.
Okay, juror 1219, why don't you remain seated there for a moment?
Okay.
We will bring back in jurors, should be 906, 1020, 1159, 1167. All right. Gentlemen of the jury, you've been passed for cause at this time, or any challenges have been overruled by the court, allowing you to go to the peremptory challenge phase of this case, which will take place in all likelihood later this week. So you'll be required to report back again. The jury commissioner is going to contact you, and at this point we'll give you a card that's the business contact information for the jury commissioner, who will give you your further instructions to report. Just please be on standby. That could happen fairly soon. Very importantly, while you are waiting to come back, please continue to follow the previous admonishments you've been given several times to not in any way go look this case up, watch about the case, learn about the case. If you see anything reported about the case, please turn that off or disregard it so that you can continue to be somebody that would be impartial enough to serve on this jury in the case, which you've been determined to be up to this point. While waiting also, if anybody approaches or questions you or follows you or wants to talk to you about your jury service, please report that to the court, because you're not allowed to engage in those discussions at this point. So with that in mind, that will conclude the individual voir dire for this group of jurors. Does the state have anything further to say before we let them be excused?
No, Your Honor.
All right, anything further from the defense? Okay, I'll rise for the jurors, and then we will discuss scheduling. We've got a second group to come today that's scheduled. Yeah. Please be seated. All right, counsel, thank you for your efficiency today. Our 11 o'clock group is here. We do need to take a break. I'd like to get started with that group, and I'll just discuss briefly with administration, thinking that we can perhaps have a lunch break while we're doing this second group and not go through the whole thing without them or us having the lunch break, so we can get into the afternoon if necessary also. Let me discuss whether or not that's a feasible plan, or whether we should take a break now and go straight through, and then we'll let you know. Just give me a few minutes to discuss that, and then I'd prefer to get started with them and then break perhaps while we're doing the voir dire. Okay, we can start the simulcast, and we're ready to go on the record.
Thank you, Judge. It's live.
Okay. We will go on the record again on CR 22211624, State versus Lori Vallow. The parties are all present, as is the defendant. We're ready to start with our second group of jurors for individual voir dire. The court's received agreed to challenges, which we'll put on the record once the jurors are brought in. So at this time, the court would ask the bailiffs to bring in the next group, please. Bring the. Okay, thank you.
All right, please. Panel's all present, counted for you.
All right, thank you. Please be seated. All right, this is case CR 2221-1624, State of Idaho versus Lori Vallow. We are going through voir dire of jurors in the case at this time. A group of 15 jurors has been brought in. The court has reviewed the acknowledgement signed by each of the 15, indicating they've complied with the court's prior admonishments while they were since the time of filling out the questionnaires. We'll do voir dire of this group then, and I'd like to welcome you all back and thank you for reporting back as requested to do so by the court for this process. The first matter we'll take up is that the questionnaires have now been reviewed by both the court and counsel. After going through those questionnaires, the parties have raised certain challenges, and the court's prepared to make a ruling on those by also indicating there's been stipulations from both sides. So, ladies and gentlemen of the jury, if you return, I'm about to read off the numbers of certain jurors that have been challenged. If you are excused, please don't feel offended or feel that there's something you did wrong. We're simply trying to make sure we have the most impartial jury we can for this case, and also jurors that are able to fully serve and give their entire dedication to this case during the long time frame it will take to try it. So for certain of you, the challenge has been raised, and I'll indicate who that is at this point on the record with each one. After I've concluded reading the group that's been excused, then you'll be free to leave, and I'll give you a final instruction before you go. And so starting off with the first challenge was juror number 1319. The parties reviewed the questionnaire and believed that the juror indicated a hardship requiring them to be excused from the case. Does the state object to a hardship excusal for 1319?
No, Your Honor.
Does the defense agree?
Yes, Your Honor.
All right, juror 1319 will be excused based on a hardship. Juror 1324, that juror also, based on the review of the questionnaire responses as it relates to the time frame of the trial, indicated a hardship. The state and defense have both raised a challenge on that cause, and the court would find good ground as well. Does the state agree that juror 1324 can be excused for hardship?
Yes, Your Honor.
Does the defense agree?
We agree.
All right, thank you, counsel. Juror number 1326. Upon review of the questionnaire for this juror, the parties determined that a challenge should be raised raised for the reason of bias, and the court, upon review of the questionnaire, also confirms that. Is the challenge on 1326 from the state for bias?
Yes, Your Honor.
All right. Does the defense agree with the challenge?
We do.
Very well. Juror 1326, the court will affirm, has been excused also on the basis of bias. Juror number 1377. Court's also reviewed the questionnaire there. Does the state challenge juror 1377 on the grounds of bias?
Yes, Your Honor. Yes, Your Honor.
Defense agree with the challenge?
We do.
All right. The court agrees as well that based on some pretrial exposure to the case by this juror, news coverage of the case, they'll be excused. Juror number 1554. A challenge was raised based on bias also for this particular juror. Is that the state's challenge?
Yes, Your Honor.
Does the defense agree with the challenge?
We do.
Very well. The court has reviewed that questionnaire also and finds grounds for excusal of this juror based on bias. Juror number 1604. Parties also, upon review of the questionnaire, indicated to the court a challenge would be raised based on bias. Does the state raise that challenge?
Yes, Your Honor.
And does the defense agree that this juror should be excused for bias?
We agree.
The court will find that also for an excusal for cause for juror 1604. And then juror 1621. Could I have a brief sidebar with counsel on this one?
But just for the sidebar, I need it. So, yeah, I'll ask him if would you hit the button when they get back on the record. Yeah, the one in front of the judge. Thank you. Judge, we're just resuming the simulcast one moment.
Okay.
It's live. Thank you, Judge.
Okay, thank you. The court reviewed a potential challenge on 1621, and that juror will remain for further voir dire at this time. So going back through the list then of jurors I mentioned, 1319, 1324, 1326, 1377, 1554, and 1604. The court will excuse you from your jury service. The court very much and the parties appreciate the time you've committed to come in and fill out your questionnaires and return today. Please don't take any offense on the fact that you've been challenged. It has nothing to do with your honesty or integrity. It's simply the process we go through to try to obtain the most impartial jury we can to try this case. So with the appreciation of the court, you can be excused, and I will just advise you, if you wish to talk about your jury service with anyone, you can do that, but please respect the feelings and privacy of your fellow jurors and only talk about your own perceptions. If somebody persists in talking to you and you don't want to talk to them, please report that to the court and we'll take that issue up with whoever's doing that. So that will conclude your service for today. If I read your number off, and you can be excused. All right, the first thing I'll discuss then with the remaining jurors is our schedule here. I know you've already been here some time. We've been going since the morning, and we'll want a lunch break. We've accommodated to get you something to eat here at the courthouse if you do want to have a lunch break. We're going to get started and go for some time now, and probably in about 20 minutes or so, around 12:30, we'll be taking a break during this process, so you'll be required to stay here during the break, but again, we'll have lunch brought in for you if you're hungry, and then we'll continue on with that. Otherwise, the process will just take too long to get through given the timing, so that's the schedule we'll be following. All right, at this time then, I'll thank you again for returning. I'll reintroduce myself and the court staff again. I'm Stephen W. Boyce, the District Judge of Fremont County. My court clerk is Shannon Holstein for this case, and she will be keeping minutes of these proceedings and administering oaths to you. We have the bailiffs here who are assisting me with maintaining the courtroom order and working with the jury. Our court reporter here is taking the stenographic record of the proceedings, and my staff attorney, who sits over at the table by the window, occasionally will assist me with legal issues that arise. Each one of you is qualified to serve as a juror of this court, and each of you filled out your questionnaire, as I mentioned, that's now been reviewed by the parties in the court. The first thing we need to do in this trial is to select a total of 18 jurors, which will be 12 jurors and 6 alternates. At this time, in order to make sure we have the record clear of who's here, I'll request that our court clerk take a roll call of you as jurors. So she will call you out by your red card number. Once you hear your number, if you'll just indicate audibly here, then we will complete the roll call. So Madam Clerk, would you do the roll call at this time?
Juror 1265. Here. Juror 1381. Juror 1462. Here. Juror 1465. Juror 1535. Juror 1560. Juror 1621. Juror 1628. And Juror 1631.
Okay, thank you. This time the court will then introduce the parties and the case again to assist you in understanding this process. The case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state is represented at this trial by Lindsay Blake, who's the prosecutor for Fremont County, by Rob Wood, the prosecutor for Madison County, and by Special Appointed Prosecutor Rachel Smith. The defendant, Lori Vallow, is represented by her attorney, Jim Archibald, and her attorney, John Thomas. Thank you, counsel. This case is a criminal matter, which means the defendant has been charged by the state of Idaho with a violation of the law. When you were here last week to complete your questionnaires, the court read a summary of the charges that are contained in the indictment. I'll read you a more brief version of that indictment at this time the list of the charges included in the indictment. So with regard to the defendant, the state of Idaho has alleged that Lori Vallow Daybell committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception, count 2, first-degree murder, count 3, conspiracy to commit first-degree murder and grand theft by deception, count 4, first-degree murder, count 5, conspiracy to commit first-degree murder, and count 7, grand theft. The defendant has pled not guilty to all the charges. Please remember that is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove her innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If, after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is, or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, tweeting, blogging, electronic bulletin boards, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I will ask that the court clerk administer the oath to the jury panel. So, ladies and gentlemen of the jury, would you please stand and raise your right hand?
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God?
Okay, thank you. Please be seated. At this time, I'll inquire of the parties. Will the state stipulate that these jurors have been properly called, impaneled, and seated?
Yes, Your Honor.
Will the defense also stipulate that the jurors have been properly called, impaneled, and seated? Thank you, counsel. In this part of the jury selection, you will be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, I would ask that you just raise that red card you have with your juror number. We'll also instruct the attorneys to only refer to the jurors by using the red card. I'll also indicate that for your privacy, there are cameras that in the courtroom for the simulcast that's occurring in 2 other locations, but you are not on those cameras. So we'll use the red card numbers for anonymity of the jurors in order to keep a clear record. When you're asked questions, if it's yes or no, please answer verbally yes or no instead of shaking your head or nodding your head or saying uh-huh or uh-uh. Also, please try to avoid talking at the same time as any attorney questioning you or the court so that the record remains clear that way also. In this case, there's been a lot of pretrial media coverage and publicity. We want to make sure that you don't discuss any facts you know about the case in front of your fellow jurors, because there will be a time to discuss that with you individually regarding any knowledge you may have about this case. Also, if there are any other matters of a sensitive personal nature that shouldn't be heard by the public, then we can also arrange to discuss those matters in private with you. And counsel is instructed to notify the court if we're going to question jurors on any of those issues. I'll also instruct the attorneys for both parties to avoid repeating any questions that have already been asked, and the attorneys do have the right, however, to direct follow-up questions to jurors regarding any response to previous questions. In terms of the juror challenges, as you've seen here today, several jurors have already been challenged. Again, each side does have challenges called for cause, by which I mean that the side can ask a juror be excused for some specific reason. In addition, each side has a certain number of peremptory challenges, by which I mean each side can challenge a juror and ask that he or she be excused without giving a reason for the dismissal. If you're excused by either side, please do not feel offended or feel your honesty or integrity is being questioned, because it is not. This time then, the court will commence with the beginning of my questions for you, and then I'll let counsel have their voir dire after I've completed mine. So the first question I'll ask for all of you as a group is, in regards to the questionnaires that you completed last week, are the answers provided in your questionnaire still true and accurate today to the best of your knowledge? Yes or no? Okay, thank you. All the jurors answered yes. Let's next talk about the time commitment that would be required for this case. If you're required to serve as a juror in this case, it would be for a period of approximately 8 weeks. Would that time frame required to do that create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case? So if you want to discuss the time required to serve, please raise your red card. Okay. Did you want to discuss the issue? Okay. Juror number 1381.
I work for the banking system, so I have obligations that way, and then I have prior travel arrangements next week, so I don't know if that will conflict or not.
All right, let me ask some more questions about your employment. Have you discussed with your employer the possibility that you may be required to serve here?
Yes.
And did they? What did they indicate would be their policy?
They're okay. It's just they got to find somebody to cover for me, I guess.
Okay.
So, but they were okay with it, though.
And would it cause a financial hardship to you, or would you continue to be able to be compensated if you served?
I think I should be able to be still compensated.
Okay, and the attorneys will have some follow-up questions, I'm sure. Can you explain a little more about the travel arrangements you have when that is?
My son, he's a senior in University of Montana. He runs track, so we already had a prior commitment to go down to Long Beach to watch him in his track.
And when would that be?
Next Wednesday through Saturday or Sunday, I guess.
Were you going to fly to Long Beach or drive there?
We're flying.
Do you know if your airline tickets are refundable or not?
I'm not sure. My wife does all that stuff, so.
All right. Let me have some follow-up voir dire, if I may, from the state first and then the defense.
Okay.
The state doesn't have any follow-up questions right now.
All right. Does the defense?
Your Honor, the defense does not have any objection to excusing this juror for cause based on his hardship.
What's the state's position on a for-cause excusal for hardship for this juror?
Your Honor, I think with the request to move him for cause, we would have a follow-up question.
Go ahead.
So, sounds like you have a trip planned to watch your son run track. Not sure if the tickets are refundable or not. If they are refundable, is there another opportunity that you would have to go watch your son run track, or is this a single event?
Could we get the microphone to him so we'll get that response on the record? Thank you.
It's not a single event. He's in track season, but it's going to California. It's his first time going. He's a senior, and this is his last year of running track.
Okay, Your Honor, given that response, the state doesn't have an objection to him being released based on that hardship.
Okay. The court's reviewed that, and based on the challenge of the defense, joined in now by the state, I do find that Juror 1381 has presented good cause to be excused for purposes of hardship. So thank you for reporting back and for your commitment. The previous admonishment I gave about if anyone wants to talk to you or you talk to them would apply as well. And with that, you can be excused. You're welcome. All right, when I initially asked also, I didn't see any other people raise their hand on the time commitment. Okay, we do have another juror that would like to discuss that, and that is Juror 1560. Would you explain how being required to serve may create a hardship for you?
Yeah, so I have a full-time job. I'm actually the only employee at the moment for them. I have discussed it with them, and it's not a problem at the moment. I also am a single mother, so my daughter does not go to daycare. My mom actually watches her, so it will be doable, but it will be difficult for 8 weeks.
All right. Any voir dire by the state on that issue?
Just to clarify with you, I know you've indicated it would be a hardship, especially if it was for the full 8 weeks, but you also indicated it's doable. Is this something that you could manage between work and childcare?
Yes, it will be difficult, but yes, I could. I have discussed it with my mom, and we could do it.
Would anything about that cause you concerns with your ability to come in and pay attention to the evidence being presented in light of the schedule given by the court?
No.
I don't have any further questions.
All right. Thank you. From the defense?
Ma'am, you indicated that you had talked to your employer and you're the only employee at the time, at right now. Is that right?
Yes, that's correct.
And so what are they? They're just going to shut down the shop for 8 weeks?
I'm not sure what he's going to do. He actually is in the process of trying to hire someone right now.
Okay.
I'm not sure. He hasn't really gave details on that.
So you being the only employee, are you on salary?
I am.
Okay, and they're willing to pay you your salary for 8 weeks?
I haven't discussed that with him yet.
Okay.
I can discuss that with him though, but I'm not sure what he would say about that.
Can I ask a follow-up question?
That would help me.
As the sole employee, is there some possibility that your absence could affect the business going forward? In other words, would you potentially not have a job to come back to if you were gone for 8 weeks?
There's a possibility. I didn't get much details from him. I'm sorry.
Okay. And the child you have at home is 2 years old, is that correct?
That's correct.
All right. Well, the court is going to find, based on your responses there and some potential peril for your employment if this occurred, even though your employer apparently has been very kind in allowing you to serve, being the sole employee, I think creates a hardship for you that may occur if you had to serve the entire time of this case in addition to caring for your child. So the court will find that Juror 1560 meets the requirements to be excused for a hardship reasons. So Thank you so much for your time in reporting today. And as I've mentioned to those other jurors that were excused, if you choose to talk to people, please be respectful of your fellow jurors. And if somebody wants to talk to you and you don't want to talk to them, just report that to the court. All right, with that, you can be excused. On the issue then of the time frame required to serve, did anyone else have a concern? All right. Let me next go through questions about, well, I'll indicate on the knowledge of the case section, we'll come back to that individually with you about any information you have about this case that you learned before you came to court. I'll next ask you some questions about the subject matter of this case. Would the subject matter of this case, which involves charges of murder, conspiracy, and theft, would that make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? All right, all the jurors said no. There's next questions I need to ask you, which might seem obvious based on your questionnaire responses, but in order to determine if there's any implied bias under Idaho law, I ask these questions of every juror. Are any of you related by blood or marriage to the defendant, and I'm referring to the defendant Lori Vallow, or do you know her from any business or social relationship? Okay, everyone said no. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys? Okay. Everyone said no to that. Are any of you a party in any civil litigation against the defendant? Everyone said no. Have any of you ever brought a criminal complaint against the defendant or been accused of a crime by any of the prosecutors in this case? Okay, everyone said no. I'll next have the counsel introduce themselves and who works in your offices in order to go through the next set of questions. So starting with the state, if you'd please introduce yourself and also the other prosecutors and attorneys in their offices, then we'll ask the defense.
So I am Lindsay Blake with the Fremont County Prosecuting Attorney's Office. In my office are also Tanya Rawlings, Rocky Wixom, and Blake Hall. We also have Rob Wood here, who is the Madison County Prosecutor. Within his office are Mackenzie Cole, Spencer Rammel, Adam Garvin, and Troy Evans. Then we also have Rachel Smith here, who has been deputized in both Fremont and Madison County as a deputy prosecutor in both offices.
All right, thank you, Ms. Blake. Mr. Thomas?
Thank you. My name is John Thomas. The attorneys working in my office are Jordan Crane, Tyler Salveson, Alex Sosa, Paul Butikofer, Brad Rigby, Justin Bowles, Tim French, and Jason Gustavus. And we work in eastern Idaho.
All right, thank you. And Mr. Archibald?
I'm a sole practitioner on my own.
Okay. Having heard the names of all those attorneys, then I'll next ask this question. Are any of you as jurors related by blood or marriage to any of the lawyers, or do you know any of them from any professional, business, or social relationship? All right. Do any of you have any kind of an attorney-client relationship with any of those lawyers mentioned or the lawyers here today? Everyone said no to those questions. Let me next ask if you've ever previously been on a jury. Have any of you previously served on a jury? Okay, we have no's except for a yes, juror 1462. All right, let me ask you a few questions about that. when you previously served on a jury, was that a case that actually went through a trial? Okay, and were you part of the group of jurors that determined the case?
Yes, I was.
When was that?
It was the early 2000s. I'm not sure of the exact year.
And where was the court where that happened?
Los Angeles County.
Was it a criminal or a civil case?
Criminal, I believe, was drunk driver.
Okay. And was there anything that happened when you were previously serving as a juror that you think would in any way impact or affect your ability to be fair and impartial in this case?
I don't think so.
Okay, thank you for your response to that. Anyone else previously been on a jury? All right, everyone else has said no. I'll next ask some general questions. Have any of you ever formed or expressed an unqualified opinion that the defendant, Ms. Vallow Daybell, is guilty or not guilty of the offense charged? Everyone said no. Do any of you have any bias or prejudice either for or against the defendant? All right, everyone said no. As it relates to witnesses, the questionnaire listed the witnesses that may be called to testify in this case, and you were instructed to identify any witnesses that you might know. Are your answers in the questionnaire still true and accurate to the best of your knowledge? Okay. Is there anything, having thought over this since you filled the questionnaires out, is there anything in your questionnaires you think should be changed at this time? Okay, everyone said no. Are any of you unwilling to follow my instructions to you, the jury, as to the law you must apply in determining the case? Everyone said no. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict? Everyone said no. Are there any of you that if you were selected as a juror in this case would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? All right, everyone said no there. And finally, do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? Okay, everyone said no there. That would conclude for now the court's voir dire. The attorneys will now have an opportunity to do that. Looking at the clock, I think this will be our time to take a lunch recess. I'm thinking, counsel, if we could, let's try to resume again at in about 45 minutes, so 20 after. And we'll resume then with attorney voir dire of this group of jurors. As I mentioned, if you would like lunch, I believe it's provided or probably on the way if it's not there yet. So thanks for your patience in going through the lunch break with us, and we will be in recess for now.
This is continuous coverage.
Continuous coverage.
In the trial of Lori Vallow Daybell from the Hidden Killers podcast.
Hidden Killers podcast.
There is more to come. Press subscribe so you don't miss any of it. I'm Tony Bruschi. Stay with us.